So to walk us through the legal side of all of this, we want to bring on Leon Fresco. He is an immigration attorney and former Deputy Assistant Attorney General for the Office of Immigration Litigation at the U.S. Department of Justice. Leon, it's great to have you. Although the Trump administration initially said that Khalil had a student visa, he has a green card. So what's the difference here legally, and what rights does a green card holder have?
Well, normally there would be a huge difference between a student visa and a green card with regard to how difficult it is for the government to revoke. A student visa is much, much easier. It's literally done in an email, and then ICE can come and remove you from the country. Whereas a green card has to be done through removal proceedings where you're charged with a ground of removability. Here, what's novel about this is that the ground of removability that's being charged is a rarely used ground about the Secretary of State saying that your presence in the United States causes serious adverse foreign policy consequences to the United States. And so this is going to lead to a slew of untested, a slew of untested constitutional questions that the court is going to have to consider about whether a Secretary of State's determination is even reviewable or not. So he may not even get to have a trial in immigration court about whether he was a nice person or not. If the secretary makes this designation, that may be all that is needed under the law. And so we're going to see what the courts have to say about this.
Well, how can just the secretary's designation that it's inimical to the foreign policy interests of the United States or whatever overcome his rights under the First Amendment as a green card holder?
Here's what's complicated about this situation. There's actually pretty bad case law on this. 1952, a case called Harrisiadis versus Trump, which had to do with membership in the Communist Party. And basically all of these exact same arguments were made. It was a green card holder. It was someone who was married to U.S. citizen, had U.S. citizen children. And the question was, well, do I have First Amendment rights to have been a member of the Communist Party? And these were people saying they were past communists and they shouldn't be deported because they had renounced the Communist Party. And that case, which is still a good law, says that when Congress passes a law that has a ground of deportation in it, even if it applies to lawful permanent residents, the courts basically have no business overturning that ground of deportation. And so they would say if the American people don't like this ground of deportation, they should get the Congress to change it. That's the case law from 1952. It will be very interesting to see if this court wants to put some barriers on that case law and actually allow this individual to say, but I'm not a person who causes severe adverse foreign policy consequences to the United States. We will have to wait and see.
So, Leon, the Department of Homeland Security justified the decision by saying that Khalil actually led activities aligned to Hamas, a designated terrorist organization. But where's the evidence to show that? And what is the threshold to legally deport someone over this? Because this question was asked in the White House briefing today. The press secretary saying that there were flyers he was passing out with the Hamas emblem name on it. But we haven't seen the flyers.
Well, that's going to be part of the two questions. So question one, is this Mahmoud Khalil actually going to get in day in court where the government has to present evidence that he is posing severe adverse foreign policy consequences to the United States, and then he gets to present evidence saying he never did anything, and an immigration judge gets to decide that issue, and then that issue works its way up to the courts? Or is the immigration judge going to rule that if Secretary Rubio says it, that's all that's needed? And then will that issue have to work its way up to the courts first? The meaning, does Secretary Rubio just get to say whatever he wants in this situation? And then if the Supreme Court says, no, there are checks on that, then they would have to come back down a second time to have the actual trial on the issue of what this individual actually did or didn't do. So it will be interesting to see if the immigration judge decides not even to go there and say, all I can do is just take Secretary Rubio's designation and deport him, or does the immigration judge actually allow a trial to take place on these grounds? So that way that would save time in case there's an actual appeal moving forward.
Got it. Leon, you made a complicated situation very clear for us, and we really thank you for that.
Thank you. My pleasure.